All right, so we're going to call the meeting to order. And as a preliminary, I need to read this statement. Due to Governor Greg Abbott's March 13th, 2020 proclamation of a state of disaster and September 7th, 2020 extended proclamation of a state of disaster affecting all counties in Texas due to the coronavirus, as well as the governor's March 16, 2020 suspension of certain provisions of the Texas Open Meetings Act, the Texas Forensic Science Commission meets virtually today as authorized under Texas Government Code Section 551.125. So agenda item 1 is a roll call for members. So when I call your name, if you just announce that you're here, I'm obviously here. Dr. Bruce Badoli.
Here.
Dr. Jasmine Drake.
Here.
Dr. Sarah Kerrigan.
Here.
Mr. Jarvis Parsons. Apparently lost in the Ethernet somewhere. Was on the phone, is alive. Mr. Mark Daniel, who is not here. Dr. Patrick Bazzini.
Here.
Dr. Nancy Downing.
Here.
Okay, so everybody and Mr. Parsons is somewhere trying to get into the meeting. So Pat Johnson has retired, so that position is currently open. Mr. Daniels is out of town. All right, so we'll move on to agenda item 2, which is the instructions for public participation in meeting process. Lee, if you can give the instructions, please.
Sure. Good morning, everyone. If you're a member of the public or a representative of a crime lab, throughout the agenda, we'll have time for you to comment on agenda items that are applicable to you. And we kind of know who's here to comment on what items. But if you have something on a particular agenda item that you want to provide comment on, just shoot a message in the chat to everybody. And if we have time, we'll unmute you and permit questions at that time. And then at the very end of the meeting, we'll have an open public comment period where if you weren't otherwise able to provide your comments during the meeting, you can provide it at that time. We do try to limit the public comments to 5 minutes. Sometimes we make adjustments to that where it makes sense to. So try to keep the comments to under 5 minutes if you can. I think that's it. If you have any questions, just shoot me a message in the chat.
Okay, agenda item 3 is the review and to adopt the minutes from the July 24th, 2020 Forensic Science Commission quarterly meeting. Is there any discussion regarding that? If not, do I have a motion to accept the minutes?
Move.
Is there a second?
Second.
All those in favor say aye.
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 Opposed? Okay, that motion passes. The 4th agenda item is going to be the office administrative update and budget status report, and then the 2020 budget closing. So Lynn, if you would proceed with that.
Yes, before we do that, Dr. Barnard, I see that Jarvis Parsons has joined.
Yes, sorry guys. I apologize.
Can we mark?
Okay, so Mr. Parsons, for the record, Mr. Parsons is virtually in attendance at this meeting. So if you want to move forward.
Sure thing. In your materials, we have reflected actually 3 budget items, one being the first quarter or fiscal year budget status report, the budget closeout from last fiscal year, as well as the legislative appropriations request for the entire Office of Court Administration budget. We are an agency within the Office of Court Administration, so our LAR is reflected there. The commission's budget is doing just fine. You can see by the numbers, even with the 5% reduction that the governor requested. A big component of that is that we have not been doing any traveling. So there's quite a bit of savings there, both because commissioners typically travel, staff travels. We do all kinds of conferences and things, all of which have been moved to virtual status. So we've been able to save some funds there. So does anyone have questions about any of those items?
As just a general question, besides the travel savings, what other cuts occurred to the budget beyond the travel, if any?
So some of the items we weren't able to take anything from because they're fixed costs, but the ones, the areas where we do, for example, forensic development work. So we would refer to that as, say, joint conferences hosted with the Court of Criminal Appeals, which we've done in the past. Typically, we would spend money on those types of activities, and we haven't because we're not holding those in person.
Okay.
The StarMix working group would have come together and has not. So that's something that we are going to take back up again, but virtually. Mostly it's in those areas involving conference planning and things like that.
Okay.
We've been really focused on the core mission, and we'll be picking some of those efforts up again, but they certainly slowed down due to COVID.
All right, thank you. All right, so at this point, unless, Lynn, did you need to move forward with other information, or can I move forward with my nomination?
Well, I think we should recognize that Pat Johnson has retired. Pat was with the Department of Public Safety for more than 4 decades before he was appointed to the commission. And he has attempted multiple retirements, and this time it looks like he finally is doing it for real. So I just want to express our gratitude, the staff's gratitude for his service. And we've been in touch with him, and so has the governor's office. And so if anyone would like to contact him or reach out and wish him well in his retirement, I'm happy to provide his contact information. Just let me know.
Thank you. All right, this time, since we have a vacancy in the vice chairperson's position that would preside over the quarterly meetings in the event that the chairperson, which would currently be me, is unable to attend. So we've had that, which certainly required that I be in attendance in all of these. So just as a protection, we're going to appoint, well, we're going to ask and make a motion with regard to a vice chairperson. And so at this time, I'd like to nominate Dr. Jasmine Drake as the vice chairperson.
I'll second.
Any discussion by anyone?
Dr. Drake, is that acceptable to you?
Yes.
Oh, yeah. I guess we ought to make sure that you agree to that.
That's a good.
Although it's like missing a meeting where when you miss a meeting, you're immediately appointed to a committee. So
I was going to say that my motion is presupposed that I was speaking for Jasmine in accepting the position.
all right. So the motion has been made and seconded. All those in favor, say aye.
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 Opposed? And Jasmine, you can't vote. Against it. All right. That motion is passed. Thank you very much.
Thank you, Desmond.
So the next agenda item is going to be the discussion of pending complaints and self-disclosures. Dr. Drake is going to be handling that in the absence of Mr. Daniel.
All right. So I'll try to be as efficient as Mark in driving this ship. So we'll move right through. So this time we have 5 self-disclosures, 3 complaints, and 1 self-disclosure that's pending from the July meeting. So for our first self-disclosure is number 20.44, and this disclosure comes from NMS Labs. This incident is dealing with, they were training some new analysts, and they realized that incorrect allele frequencies were being used to calculate and report statistical values in their casework. So the 4 published sources for allele frequencies that are typically utilized across all software platforms were not available to staff and differed from those in the SOP. So they did notice that there were some transcription errors. Additionally, some of the minimum allele frequencies were calculated incorrectly. This affected some of the random match probabilities, likelihood ratios, combined probability of inclusion, exclusion for autosomal STR comparisons, as well as the biological relationship indices for some of their work. The lab determined the incident did not affect reported conclusions from profile comparisons, but there were some issues with the statistical values that were reported in some of this casework. So for the corrective actions, the lab suspended casework that required an autosomal STR statistical value calculations. They also reviewed and confirmed all of the allele frequencies in all of the software programs and updated those to the references provided by NIST. 2 different staff now independently check the values to ensure accuracy, as well as they checked the formulas and the software, updated the software programs for casework. And we also received an update from the lab director, Barry Logan. The lab did a review of the cases that contained the autosomal STR statistics for these cases. There were potentially 167 cases that were affected. So the report is expected by November of this year. So the staff recommendation was to table it at the July meeting, and the staff continues to recommend to continue to table the pending the receipt of the lab's report, which is due out in November. Do we have any comments, questions, or discussion?
Dr. Drake, I think we have some NMS folks on the line. Does anyone, or Dr. Bedoli, since you're lead DNA person, anything else that you want to add, or does that seem?
No, it seems like they're addressing it appropriately. My expectation is that some of the calculations they had were, it's probably going to be random. Some are going to go up, some are going to go down. So they may have overestimated some, underestimated. So they may want to at least capture the degree of that. Because I mean, if you underestimated and made it less weight, that's different than if you overestimated. So maybe in the report, just capture that information.
All right, so a motion has been made to table this until we get the receipt of the laboratory's report detailing its review and findings. And that is expected before the next meeting, I take it.
Yes.
All right, is there a second?
Second.
All those in favor say aye.
Aye.
Opposed? Okay, that motion carries.
Okay. All right, so our second self-disclosure is 20.48, and this is in the DPS seized drugs section. There was an analyst trainee who submitted 1 or more plagiarized departmental exams and exercises during his new employee training process. A supervisor noticed him looking at his notebook while taking the exam. He also copied some of the extraction exercise examples in one of the, I guess, training exercises. He admitted to the cheating ultimately. His section supervisor forwarded the information to the Office of the Inspector General for administrative investigation. The OIG found that he violated several lab policies, and they recommended termination of his employment. He appealed. This appeal was denied. He's licensed in seized drugs, but there's no further information on his subsequent employment at this time. DPS Austin was actually removed as the designation on his license, and his license status was changed to inactive. The staff recommends that the commission to begin and to investigate to assess if the lab's conclusion regarding his professional misconduct and violations of the Code of Professional Responsibility are supported. If the commission issues a finding of misconduct against the analyst, disciplinary actions can be taken against the analyst's license. and there could be a change or a possible revocation of his license. Any questions, comments, or discussion?
Is there a recommendation? Is there a motion?
The recommendation was for the commission to do an investigation to assess the lab's conclusions on his professional misconduct.
Yeah, sorry about that. I actually meant, is there a motion? So the recommendation has been to impanel a group to investigate. Is there a motion for such?
Make a motion.
Is there a second?
Second.
All those in favor say aye.
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 All those
Aye.
opposed? Okay, motion carries. Now we need to create the panel, one of which, as a welcome to Vice Chairman, would be that we believe Dr. Drake would be great to head this panel up. And I think that Dr. Kerrigan, would you be willing to serve as well?
Yes.
And since Mr. Daniel is not present, we will volunteer him for the third position.
Well done.
Yeah, we're not done with you probably either. Okay, so is there a motion to accept this panel?
So moved.
Second?
Second.
All those in favor say aye.
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 Opposed? Okay, motion carries.
Okay, so we have another self-disclosure out of the Tarrant County Medical Examiner's Office. This is 20.49, toxicology, evidence handling, and packaging. For this particular incident, an analyst mislabeled a hospital admit tube that was submitted for toxicology testing from 2 different cases, resulting in switch samples, and the results reported were reported under the wrong case number. So essentially, the analyst actually stapled packaging for one of the hospital admit tubes to the wrong case in error, and then prepared the sample for testing without noticing the switch up. And that led to the wrong case number being used. So the lab discovered the error when the evidence was being checked back into their vault, and didn't match the medical examiner's case number of the evidence being scanned. So the lab did a root cause analysis. They found that the analyst's error in pairing the wrong tubes was part of the issue. Also, that they didn't have any type of automated process for adding case numbers to the labels for the toxicology samples, as well as the inconsistent process for labeling due to COVID-19. Personnel scheduling. So I guess they had some issues with personnel scheduling and interruptions to traditional workflow. The lab's corrective actions were that they now prohibit stapling of the packaging together. They also have created a new automated process for adding the tox labels and the case numbers to those tubes. They also did a thorough review of all the hospital admit tubes submitted from the previous 2 months. They didn't find any additional mistakes. They're currently monitoring the corrective action by pulling samples that were submitted in August and September to look at the accuracy. The lab is going to update the commission on the outcome of this review. They will also conduct a representative sampling of the tox tubes for 2 months after the completion of the corrective actions. For this one, the staff recommends that the commission take no further action on the disclosure given the root cause analysis and corrective actions taken by the lab. The staff will update the commission if any material changes emerge as a result of the corrective action monitoring phase. Are there any questions or comments or discussion on this one?
All right, is there a motion for no further action?
So moved.
Second?
Second.
All those in favor say aye.
Aye.
Opposed? Okay, motion carries.
Okay.
Hey, Dr. Barnard, you're gonna need to recuse on the next one, so Dr. Drake will need to handle all.
I think we got one more to go before that.
I'm sorry, I skipped. I apologize. Excuse me.
You just wanted me recused?
No, I apologize. I forgot there were 2 Tarrant County items
Yeah.
here.
All right.
So the next self-disclosure is 20.50. It's the Tarrant County Medical Examiner's Office Crime Lab, and this has to do with toxicology proficiency tests. So in the proficiency testing, they noticed that PCP was not detected in the tox proficiency test, leading to a false negative. The lab concluded the non-conformance result of the loss in due to the loss in sensitivity of the instrument analysis over time. For their corrective action plan, they reviewed the original screening of approximately 1,500 cases for the presence of PCP. What they noticed from this review was that there was one impaired driving case identified where the PCP was found to be present, but not previously identified. Additional testing performed was done to confirm the presence of PCP. The lab then notified the law enforcement agency and the report was amended. The case had not yet been filed, so they changed their process so that the methanolic analysts mixes run at lower calibration levels to help determine the lower limits of detection. So with every column change and with any instrument maintenance that's done, they also develop new instrument procedures that includes guidelines for adjusting those master methods on the instruments or for individual batches. And they also made a requirement that any master method adjustment to compensate for the loss of sensitivity must be notified. They must notify a technical leader or chief toxicologist. Based on this, the staff recommendation was for no further action given root cause analysis and corrective actions by the laboratory. Do we have any questions, comments, or discussion?
Hearing none, is there a motion for no further action?
Move.
Second,
Second.
all those in favor say aye.
Aye.
Opposed? Motion carries. This next one, I will recuse myself. So Dr. Drake, you'll have to do the motion and vote.
Okay. So for the next self-disclosure is 20.54. We have the Southwestern Institute of Forensic Sciences and the seized drug section. So this incident, like I said, in the seized drug chemistry section, this is where analysts reported incorrect results on 2 items in a seized drug case. The analysts had been released from independent casework 2 months prior due to performance deficiencies that were identified by some of his coworkers and during the tech review process by the quality assurance and quality control process team. There was excessive technical and administrative errors and failure to follow the documented lab policies and procedures by this analyst. For the corrective action, the analyst was later terminated due to unsatisfactory performance. The lab conducted an admin review of a subset of his casework, so about 36 cases. The cases that they chose a representative sample that represented the difficulty, similar to the cases that they saw he had an issue with a mix-up. During the review, the lab discovered a particular error where he incorrectly reported the results on 2 evidentiary items in one case. And so he had one clear liquid. He listed it as no controlled substance found, but it was actually later found to have GHB, which is a penalty group 1 substance. And then he had a tablet where he listed no controlled substance, but it actually had uncontrolled but scheduled, uncontrolled but should be identified item upon reanalysis, clonazepam. And so based on the lab, he should have actually listed that was present. So for the lab corrective actions, they issued a corrected report. They updated its qualitative ID procedures to provide clarification regarding color tests of clear liquids. It also did a review of an additional subset of the analyst's work, which contained clear liquids or tablets. The DA's office and ANAB were notified of all the corrective actions. This analyst is licensed by the commission and seized drugs. This expires in December. The staff updated his license status to inactive and removed his employment designation. The staff recommends no further action due to the root cause analysis and corrective actions taken by the laboratory.
Dr. Drake, can I weigh in a little bit here about why?
Mhm.
So unlike other examples that we've heard even just today, in this case, it appears that the analyst was just not good at identifying seized drugs. He missed things in multiple cases, but there's no indication of cheating or other dishonest or unprofessional behavior that would merit an investigation resulting in action against the license. It seems like he just wasn't good at his job and therefore he lost his job. He was dismissed for unsatisfactory performance. The way that the licensing program is structured under the statute, in order for him to resume work as an analyst at any forensic laboratory in the state, he would have to go through another laboratory's training program from scratch, and presumably these same issues with his inability to properly detect controlled substances would be identified during that process. So I just wanted to draw the distinction for the group about why we didn't recommend a formal investigation in this instance where we have in some others. So I don't know if commissioners have questions about why that was the recommendation. I'm happy to answer that. Certainly he was not good at his job, but he kept missing the substances and was let go for it. It doesn't seem like any of this was intentional misconduct or cheating or anything like that.
So if we don't have any comments or further discussions, do I have a motion?
I move.
Do I have a second?
Second.
Okay. All in favor?
Aye.
Aye.
All opposed? The motion carries, and we'll move on to the next item. Okay. So for the next item, we have a pending complaint. This is complaint 20.08. This is Angela Moore on behalf of Laura Day with Andrea Zafari's crime scene reconstruction for ocean drowning. The complaint by the defense attorney, who is Angela Moore, alleges that the expert witness, Andrea Zafaris, gave unqualified and unscientific opinion or testimony regarding the drowning death of a child in the capital murder trial of Laura Day, who was convicted for capital murder and sentenced to life in prison. Review of the testimony of the Zafaris testimony shows she testified as an expert in a wide range of matters. They actually pulled in two different experts on all of these different type of wave dynamics and all of that. They actually provided reports that disagreed with Ms. Zafaris' testimony. So the staff's preliminary recommendation was that cause and manner of death are typically reserved for pathologists. The Zafaris analysis may be best described as a type of crime scene reconstruction, which is exempt from accreditation by Rule 37 of the Texas Admin Code, sections 651.7A16, and that's 2020. The staff recommends the commission dismiss this complaint and request the crime scene reconstruction working group to consider the possibility of publishing guidance with respect to crime scene reconstruction involving alleged drowning incidents. Do I have any comments or questions or any further discussion on this one?
Yes, this is Angela Moore. Do I have an opportunity to object at this point to the commission's findings?
There hasn't been a finding, so you'll have an opportunity to speak when Dr. Barnard opens the floor for public comment.
May I make a comment at this point?
After the commissioners have an opportunity to ask questions, you may make a comment.
Thank you.
So there's been a recommendation. Is there a motion? Is there any further discussion by the commission? All right, is there a motion?
Dr. Barnard, I think that this would be the point when we should take the public comment.
Oh, okay. All right. Sorry about that.
Okay, is that all right, Dr. Bernard? May I?
Yes, yes.
All right, thank you very much. I completely disagree with the characterization of of Andrea Safaris's investigation being crime scene reconstruction. I hope that the commission takes an opportunity to review her testimony at trial, and that her testimony delves into the science and the mechanism of death regarding the decedent in this case. It is not simply crime scene reconstruction. I vehemently disagree with that.
So I can respond. 38.01 of the Code of Criminal Procedure states that forensic analysis involves an expert examination or test on physical evidence for the purpose of connecting the evidence to a criminal action.
Yes.
What is being done, I've read all of the testimony and agree that there are certainly aspects of the testimony that I don't even think a forensic pathologist would have offered some of the commentary that was offered, but the judge was charged with limiting or allowing that testimony. And our commission has limitations around the types of investigations we do. We can investigate anything essentially, with the exception of cause and manner of death determinations, autopsies performed by licensed physicians. However, if the commission is going to take on anything that involves an unaccredited forensic discipline, which this clearly is under both statute and administrative rule, the commission has to determine that that investigation will provide information and a work product, essentially in the form of a report that will benefit the entire forensic community, such that the resources involved in conducting the investigation are merited. And the commission has looked at, through the Crime Scene Reconstruction Working Group, other scenarios like this. And so the reason the staff is making this recommendation is because our jurisdiction around any discipline not subject to accreditation, which this absolutely is without question, is quite limited. And so the commission could investigate this, but the staff's recommendation is that it be referred to the Crime Scene Investigation Work Group, so they may decide whether they want to issue any recommendations specific to reconstruction of drowning related incidents. So just to be clear, that is both the legal rationale and the policy and staffing rationale for the recommendation we make.
Thank you, Ms. Garcia. That explains a lot. I appreciate it.
I assume you have this on an appeal?
No, we do not. We are trying to pursue 1107 under the new science, 11073, excuse me. I'm doing this all pro bono, and I have been for years. The trial court is not cooperative in revisiting this case at all.
I see. I was going to say that you might want to find a forensic pathologist as an expert witness, because it really falls more into that area of testimony. And there probably are people who would be willing to address that. But I wasn't sure if this was, looking for some grounds for appeal, but anyway. Just-
It is, in a sense, Doctor.
Yeah.
In that this individual who's the subject of my complaint, her science and methodology has been questioned nationwide, and she has indeed been struck as an expert witness in other cases. And that's the problem, as we see in these types of cases, is that individuals holding themselves out as experts in an area of what they deem is science is not accurate. And I realize the commission's jurisdiction is limited. I'll call it jurisdiction, and your abilities are limited. But when trial courts are not up on the science, and as a gatekeeper under Daubert, when they're not doing their job, that leaves practitioners and defendants at a loss of where to pursue. Because then the higher appellate courts say, well, we're going to rely on the gatekeeper, the trial court, as the referee in Daubert situations. And here we have a clear abdication of that responsibility as a gatekeeper.
Dr. Bernard.
Sorry.
Dr. Bernard.
Yes.
Yeah, this is Gaines West. I'm one of the attorneys who represents Andrea Zavaris. I'd like to address the commission if I could.
Excuse me, I wasn't finished and you interrupted me. So if I may finish, Dr. Bernard.
As a matter of procedure, I think we need to move forward since we have other people signed up for comment. We have Mr. West signed up to speak, and we've already passed the 5-minute mark for your comment. Thank you for your comments, Ms. Moore.
Thank you, Ms. Tomlin.
Mr. West represents the subject of the complaint.
Thank you.
Would you like to speak?
Yes, please. Thank you, Dr. Bernard, Dr. Drake, and members of the commission. I'll make this very brief. We provided a very extensive written submission to staff. We agree that the commission doesn't have jurisdiction, and for the rest of the commission to understand what Ms. Moore is doing is a late timed collateral attack to try to support a writ of habeas corpus. She is making statements that she can't support. The judicial branch is definitely the place where she should have lodged her complaint. She didn't. The appellate court.
Excuse me, I object to this being framed about me. We are talking about Andrea Zavaris and the supposed science she propounds, not me. This is not.
Hey, we're gonna have to keep control on this. It's not a debate.
I have to mute you, Ms. Moore. I'm sorry. It's just the procedure that we're following here. I think that when I turned the mute thing off, since you're already talking, it didn't mute. So let's let him have his comments. Thank you.
Thank you. And Dr. Bernard, I'll wrap up quickly. The complaint itself was rife with defects. There was a complaint. In the complaint, there was a reference to a report by a Flydemeyer with exhibits and a report by another supposed expert. The complainant failed to produce any of those exhibits or the report that was referred to, even after staff had requested that from the complainant. There were no CVs for these purported experts. So even relying on this report that underpins this complaint is suspect. I think there's plenty of reasons why this commission should not delve further into this complaint, because really what it is simply a last-ditch effort by Ms. Moore to survive what has already happened in her case. Thank you for hearing from us, Dr. Bernard and Dr. Drake.
All right, so a recommendation has been made to dismiss the complaint. Is there a motion?
So moved.
Is there a second?
Second.
All those in favor say aye.
Aye.
Opposed? Okay, motion is carried.
Okay. Next, we have complaint number 20.46, which is Bobby Coker against Bodie Technology, the forensic biology and DNA section. So the defendant, Bobby Coker, filed a complaint making a generalized claim of innocence. So he said there was a false report by the victim. He named Bodie Technology, but does not specifically allege any professional negligence or misconduct against Bodie. This was an aggravated sexual assault case. In 2013, HPD sent the kit to Bodie Technology. HFSC reported the DNA profile was entered into CODIS, and later they found that the defendant was a match. This was found by DPS in a routine database search. The staff recommends to dismiss the complaint for failure to allege any specific professional negligence or misconduct with respect to the forensic analysis in this case. Any questions or comments?
Okay, hearing none. Is there a motion to dismiss this complaint for failure to assert any specific credible allegations regarding the post-conviction DNA analysis in this case?
So moved.
All right, we have a motion and a second. All those in favor say aye.
Aye.
Opposed? Hearing none, the motion carries.
So I think this brings us to our last complaint that we have. Yes. This is 20.47. This is Trissa Crutcher, and this is with the Fort Worth Police Department Crime Lab, the forensic biology and DNA section. So this complaint was made by a licensed DNA analyst, Trissa Crutcher of the Fort Worth Police Department Crime Lab. She alleges a host of state and federal criminal law violations by the Fort Worth Police Department Crime Lab management and city employees. And she says there were violations of lab policies, and there's a list. Violations of accreditation standards. She also said that there was a hostile work environment and retaliatory actions taken by management when analysts would raise concerns of certain issues. She also said there was a low prioritization and unjustified delays by the lab administration in handling DNA processing of requests for child sexual assault cases. There were also edits made to request testing without tracking or documentation. Also violation of internal SOPs, and like I said before, retaliatory actions. So there are more things on that list as well, such as issues with adequacy of the self-disclosures made by the lab to the criminal justice stakeholders, as well as bullying. One allegation was bullying with the former employee, but this complaint was previously dismissed by the commission with a letter. For this particular incident, the staff would like to establish an investigative panel to review the allegations in the complaint, including a lab management response to the analyst's concerns. Are there any further discussions or comments or questions on this one?
Dr. Drake, we received findings from ANAB. They looked into various allegations and concluded that they were unfounded. But their scope of review is different than ours. And so I think the recommendation of staff still stands.
So I have a question, Lynn, if you could help. Where's our jurisdiction? Because I know we're on the science, but things like bullying and retaliation, does that fall under our domain, or can we separate out what it is that would fall under our responsibility with these complaints?
So there's a code of professional responsibility for forensic analysts and crime lab management that's Texas law now, as you know, Bruce. And there are provisions in there that set expectations for both analysts and management. So to the extent management has not lived up to those expectations, that is certainly something the commission can look into and comment on.
Okay, thank you.
All right, so the recommendation is that a panel be created for investigating this complaint. Is there a motion to create an investigative panel?
I move.
Second,
Second.
all those in favor, say aye.
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 Opposed? Hearing none, the motion carries. So in creating this panel, I think that since DNA is one of the portions of this, Dr. Bedoli, you would be a perfect candidate to head this up. And I think Dr. Downing, especially when we're talking about some sexual assault kits in children, and Mr. Parsons, you'd be great to round out this panel.
Ha.
I got away.
Yeah, no, you weren't going to get away, but anyway, is everyone willing to accept being a panel member?
Yes.
sir.
No conflicts then. All right, so the panel has been created, and so I'd like to have a motion that the panel of Bedoli, Downing, and Parsons be created. Have a motion?
So moved.
Second?
Second.
All those in favor say aye.
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 Opposed? Okay, hearing none, the motion carries. Thank you. All right, so the sixth agenda item is one in which Lee is going to discuss the status of the Crime Laboratory Accreditation Program and some of the non-conformances and reports.
Sure. The first item here is our quarterly summary of received and documented accreditation related events. And as you all know, staff looks at these as they come in, and we separate them into the disclosure side of what we do and the accreditation side. So what's documented here are all the accreditation related reports that we received this quarter, and there are 5 accreditation related events. Hopefully you all have had time to go through each of these. Are there any questions for either me or for the laboratories on any of these citations that are listed here or anything like that? Any discussion?
I don't have any questions about the accreditation summary, Lee, but I have a general comment, I think, that sort of pertains to some of the documents that we just talked about, and that is that I'm not sure if this is a concern that some of the other commissioners share, but you know, we have a tendency when we see really rigorous corrective actions and in-depth root cause analyses to dismiss the complaints. But I do wonder, as we're reviewing some of the corrective actions, if we need to revisit whether or not the labs need some additional training in that area. I can't remember how long ago it was that we did some training on corrective action and root cause analysis for a lot of the quality directors and management within the state, but it's probably more than 5 years ago. And I just noticed that when I'm reviewing these documents, the corrective action reports that we're getting are a little slim in terms of details. It's not always clear that there has been a thorough root cause analysis. When you look at the documentation, sometimes a cause is identified, but it's not really clear that it's a root cause. And I'm wondering whether any of the other commissioners or the staff share that concern, and whether or not we should reach out to the labs to determine if there's something that we could do similar to what we've done before, where we have some sort of training to readdress that issue.
So this is, from my perspective, I've been thinking about this for a while. I really do think we need to do another training. We see a lot of passive voice in the writing, so you can't really tell what's going on except something was discovered, okay? What's the timing of that? Who was discovering it? And it's not that we want to know who because we want a name. It's more that it's very hard to understand how the quality process is really working if we don't know which actor within the system discovered the error. If it's not, you know, it doesn't spontaneously get discovered. So there are lots of things, actually. There's wide variability. in terms of how thorough the quality actions and root cause analyses are that we're getting. And this is happening despite the fact that there is a section on this in the licensing materials. I think we can talk about who would be good people to bring in to teach on this. I would love to be able to put together a packet using a mock scenario that says, you know, here's a suggestion about how to do this using the various tools that are out there to do root cause analysis. So I do think, I agree, Dr. Kerrigan, that I think it's time to revisit training on this. And we have some labs that are doing an excellent job, but it's very inconsistent across our different laboratories. That's been what I've seen. And I think Lee would agree with that.
Yeah, it would be nice to have some uniformity too in what we receive, because there's such a wide variety in what is reported, and the approach to corrective actions is different lab to lab.
You know, Sarah, I fully agree with you on this issue, because I think a lot of labs within and outside Texas rely on the accreditation process as whether or not they're in good shape. And the accreditation process doesn't often dig into the professional work or the validation work. They take it at a different level. And if a lab has a finding and the lab says, I have addressed it, that's often enough. So I think it's a responsibility for our labs to get more training and understanding so that they can rise above what the accreditation process is doing and what it's not doing. It's not a fault of the accreditation process, they just don't address those points.
So yeah, we can schedule something. We can work with you, Dr. Kerrigan, on a syllabus for that and discuss what faculty might be helpful and what materials the labs may find useful.
I think it would be great, as you point out, we see a tremendous difference in the quality of the corrective actions in the documents that we review. And in past meetings, we've often commended certain labs for the quality of their investigation. So it's not that it's a systemic problem, but I am concerned that maybe even some of the smaller labs that don't have extensive personnel and quality divisions could really use some top-up training. So I think if we can provide some assistance, that might be great. So thank you.
Okay.
The next item here, if you all recall from a few meetings ago, we, as part of our accreditation report that we do each quarter, we looked at the renewal of Expertox's accreditation from their last audit or site visit, and there were numerous cited deficiencies. And so we asked them to outline those in an Excel spreadsheet for us and indicate what the responsive documents or written response was for each of those deficiency citations. And so I think Dr. Kerrigan has looked at this for us.
Well, they did receive an accreditation renewal. And so I think for the time being, the bigger question was the extent to which the CAP program requires similar things as our other accreditation bodies. And we received a response from CAP about that, but we need to do some follow-up work to touch base with them. So for now, Expertox's accreditation has been renewed by CAP, and we are going to continue to work with the accrediting body on some specific questions that we had, and we'll be back next quarter to discuss that further. I don't think there's any action that needs to be taken right now. With respect to quality forensic toxicology, I think they are one of the labs that would certainly benefit from additional training in documentation for quality incidents. That was one of Dr. Kerrigan's main comments when we looked at this particular pipetting issue. To the extent that there's anything specific that we would like them to do, we can reach out to them offline and talk about that. Dr. Kerrigan, did you have anything further on this?
No, that's good.
Okay, so we don't have any motions on this.
I think that covers C and D here, so we can probably move on to 7 unless anybody else.
I don't know, Dr. Barnard, if you want to take a bathroom break and then everything else after that, or what do you?
Do you mean me personally, or well, would everybody want to take about a 10-minute break, or do you want to?
We can keep going through licensing and we just push ahead.
Yep, that's fine.
All right, to give you guys an update on the licensing program, right now, our licensing program specialist, Rodney, is just inundated with these renewals. And Catherine and I also have been trying to jump in and help where we can. And hopefully after this meeting, her and I can focus solely on these renewals to get them pushed through. Because as you can imagine, renewing over 500 people's licenses and making sure all the boxes are checked takes quite some attention to detail, and each of the application takes a certain amount of time. We're telling applicants that it takes about 15 days from the date of submission. And what we've had to do is we've had to kind of triage the applications. So we're reviewing them earliest expiration date first. And once we clear that queue, then we're renewing them earliest submission date of the application through the end of that month. So if anybody has questions, feel free to write us. We do get a lot of inquiries, but we're happy to help where we can. We know that Top Class isn't the most user-friendly platform, but we appreciate everyone's cooperation and patience with us throughout this process. Just to give you guys a brief summary, this is in your materials, but we have 1,348 licensees right now. And those are all regular licensees. We have renewed 176 licenses, and that's out of like over 500 that we have to renew. 149 we got to renew in November. These are the numbers that expire in November, and then in December, which should otherwise be a slow month, we will renew 298 licenses that expire that month. And so we're really solely focused on these renewals, and we hope that we're being as efficient as we can in processing these. Does anybody have any questions about the numbers or anything?
So I'd like to make a comment to the lab that are on the line. Please ask folks not to leave it till the last minute. It makes it really hard for us when that happens. We don't want anyone's license to expire because dealing with a gap is harder than just getting it done. So if you have anyone who's struggling with the Top Class program or anything like that, please ask them to reach out. We'll help them. But a lot of these are coming due in December, which is typically a short month because of the holidays anyway. So we just implore folks to please ask your people to do it in advance. They should be getting notices from the system that give them their expiration date, just as a reminder. And then I think the final request that we have is if you have anyone who has left the laboratory, resigned, or whatever it might be, or is no longer going to be seeking licensure because they've changed roles, I think it would be great if you could just let Lee know, we've had 5 people resign and here they are, because that way when their license comes up for renewal and we see, oh no, they haven't done anything with it, we're not wondering, should we bug this person? What's their status? So the more you can stay in touch with us through the process, the better it'll be. So thank you. That's just my little PSA.
Can I make a comment real quick?
Sure.
Yeah.
Hey, just to the lab people, I wanted to kind of give them an update since I am very seldomly in the office. that the certificates and cards are, I've definitely fallen behind on that. And I get a lot of inquiries, you know, where's my card? Where's my certificate? I did want to let people know I am today sending off an order for cards, and they will be up through license number 1700. And what we've decided to do is we're going to maybe do the printing, the embossing of the cards maybe twice a year. So that way, probably about every 6 months from now on. I think I've got a routine down. This was new for us. So we had some procurement issues that we had to work with. We tried to get our own embossing machine, and let's just say it was not top of the line. And so I had to figure out another way to get the licenses embossed. So that is going to the printer today, and I will do everybody's certificates that are on that list as well. And I will do the best I can to package up the certificates and licenses together and send them directly to the labs.
Thank you, Catherine.
Thank you.
You're welcome.
Be excited to get that package.
Yes.
Finally.
Okay, Lee, are we done with the update?
Yep, I think we're done there unless anybody has any other questions about our licensing process, procedure, renewals, or anything like that. This first rulemaking here that we'll need you all to vote on, this just simply addresses an issue that we found in our rules, that if you read them on their face, applicants that are upgrading their licensure at renewal aren't necessarily required to do CFE if you just read the rules as the text is written. And so what we do is just add a tiny little language here that says everybody has to do CFE each 2-year license cycle, regardless of whether you're upgrading. We just didn't have that language in here, so there was a little loophole there. And so we're adding that here. Does anyone have any questions about that or suggestions for the language there? If not, we can vote on it.
All right, so do I have a motion to adopt a rule addressing continuing education requirements for licensees upgrading their license at renewal?
So moved.
Have a second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries.
All right, the second rule here, we're providing an exemption, and this is has an indefinite time period associated with it, from those elevated coursework requirements that took effect after January 1, 2019. So all those applicants that applied prior to that were not subject to those elevated coursework requirements. And so this exemption is for folks that were licensed during that time period and they've expired and they're seeking reinstatement of their license. Now they're subject to those coursework requirements unless we provide an exemption from those requirements. And I think we don't want to penalize someone, especially in the current state of the world, for taking a leave of absence or having trouble finding another job, for example, just taking a break from the field or otherwise. And we had one situation that came up where this candidate would have had to go back to college and take a chemistry course, and she's been practicing for many, many years. And so her situation kind of raised this issue that we might need an exemption here. We thought about putting a time limit on it, but I don't think we want to otherwise discourage folks from taking as long as they need. I don't know that there is an appropriate time limit here. Does anyone else have comments on this or?
Right now, I think there's a lot of empathy for folks who need to step away from work, in situation, especially with children. Sometimes that's just necessary right now with the state of the world. So we want to make sure we're sensitive to the needs of analysts who have already gone through the process.
So would this be a temporary issue or a permanent recommendation, given that premise?
This is permanent. This would be permanent. So that would just be one example of a scenario where it would make sense, but there's many others where someone stops working to have a baby and takes off 2 years. I don't think we want to penalize that person by making them take the elevated coursework. I will point out that we do require them to keep up with the CFE. So they have to take that, whatever required coursework that the commission provides, the legal and mandatory, the mandatory legal and professional responsibility course. They have to satisfy the same CFE as anyone else. But that would be the only requirement of them. They wouldn't be subject to these elevated coursework or minimum education requirements.
And those are with reference to their college coursework. So somebody gets licensed or has been licensed prior to the elevated coursework requirements, they take a leave of absence for 2 years. When they come back, as long as they've maintained their continuing education, they don't have to go back to college. That's what we're saying.
Is there any,
sorry. Go ahead.
Might be, I mean, we certainly don't want to encourage people to allow their licenses to expire by having an indefinite grace period. But what I'm hearing you say that there are a fairly large number of people affected by this, and most of them are related to COVID.
We don't know that for sure.
Yeah, we don't
Go ahead, Lynn.
We don't have that data, Dr. Kerrigan, but we do know that people get licensed or have been licensed. Because remember, before January 1st of 2019, there were certain coursework requirements that the commission had. Once we crossed that threshold, the chemistry went up, the statistics course kicked in. And what we're saying is, if somebody was licensed originally with the very first class, and then they take a couple years off, say right now, for whatever reason, if they then come back into the workforce, they, as long as they've maintained their CE, they don't have to have different formal level coursework requirements achieved. So if they don't happen to have if their chemistry was fine when they got licensed, they take 2 years off and they come back, they don't have to go back and do more chemistry. We don't know how many people this affects, but we know we're getting calls from some folks who are afraid that if they take any time off at all of a sudden, it's like they're applying for the first time. And I mean, you know, that doesn't happen if you're a lawyer. It doesn't happen if you're a doctor. It doesn't happen in any other profession, occupational license that I'm aware of.
One other thing I'll say is that in this particular scenario, the laboratory that the person was applying to had a policy that they don't hire anyone that's not otherwise eligible for the license. And they pointed out that she was missing the coursework, and so she didn't, I don't know if that's the reason she didn't get the job, but she felt like it was a big part of it. And so labs have their own policies for license eligibility and hiring, aside from our licensing scheme, and a person can't even get their license unless they're employed at a lab. So it presents some interesting barriers for folks unless we have some sort of exemption here.
It makes people who take any sort of transition at all between labs, it puts them in a tough spot, and it just doesn't seem fair, or it doesn't seem to achieve any policy goal either. So that's why Lee suggested fixing it, and I think that's appropriate.
Well, I think also your comment regarding how the licensing works for lawyers and physicians is a compelling argument. So I would make a motion that we adopt the rule.
All right, so a motion has been made to adopt a rule addressing indefinite grace period for exemption from elevated coursework requirement for licensees with a gap in employment. Is there a second?
Second.
All those in favor say aye.
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 Opposed? Motion carries.
So we have one more, Lee, is that? Oh, no.
Two more.
Sorry, two more.
Yep. This next one here, there are certain factors that we consider and that we've been considering when we take disciplinary action against a license holder, and all of those considerations are in compliance with our jurisdiction and what the law says. But as a matter of due process, we really have to put folks on notice as to what those factors are, even though we know what they are. So we've outlined them here to publish them in our rules. And a lot of this came from Robert's work in compliance. So that was super helpful. Does anybody have any comments on these considerations here? If you scroll down to the bottom, there are different factors in determining possible adverse action, and then factors that would mitigate the punishment or make it less severe or less restrictive in a certain scenario. If you all want me to read them, I can. I'm not sure.
I think one of the reasons we wanted to put this in writing is that these are generally things that we've always considered, but it is good to have them in writing so that everyone shares the same expectations and can see what the commission considers. It also tracks other much larger agencies, like, where they have thousands or tens of thousands of situations where some form of revocation is considered. And so we wanted to make sure that we are clear in articulating this to the community.
Any further discussion? Is there a motion to adopt a rule which addresses the mitigating factors to consider in commission disciplinary actions?
I move it.
Is there a second?
Second.
All those in favor say aye.
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 Opposed? Motion carries.
All right, the final rule here, if you all recall, under our old blanket licensing program, which is no longer available anymore now that we have the de minimis licensing program, there were two options under which you could achieve the blanket license as a laboratory. And the first scenario would be in a scenario where the forensic analysis they're doing or the type of method they're using is not widely available in other accredited forensic labs. But there's a second prong here that we had in this rule that's covered now under the de minimis licensing program. The request is necessary to ensure the availability of timely forensic analyses in smaller counties where access to forensic analysis may be limited. We think that scenarios in which someone would need a blanket license are under that prong are covered under the de minimis program now, and this is just no longer necessary. It should have been eliminated when we drafted the de minimis rule, and it's something that came up in between the time that we adopted the de minimis rule and now.
Okay, is there any discussion?
It's a cleanup rule, essentially.
Yes.
All right, is there a motion to adopt a rule removing the laboratory license category necessary to ensure the availability of timely forensic analysis in counties for which access to forensic analyses is limited?
So moved.
Second?
Second.
All those in favor say aye.
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 Opposed? Okay, motion carries.
So I guess that's it on licensing. Do you want me to move ahead, Dr. Barnard?
Yeah, item 8.
So this is very brief. We have finished the mandatory legal and professional responsibility training. It is available for everyone who's renewing their license. Sam Houston State University was absolutely critical partner in this, where they helped us take what was, to put it mildly, very basic PowerPoints that Robert and I put together and turned it into something that is more attention grabbing than your standard PowerPoint. And so we received a lot of positive feedback so far on it. Dr. Badoli has taken the training and we've had requests. What we tried to do was include all forensic specific examples, many out of state, some in state. Robert covers Brady and Morton, and I cover the Texas Code of Professional Responsibility. And I'm hoping that people find it valuable. There are some quiz questions included just to, make sure that folks are watching and paying attention. So I'll be curious to hear about the feedback from the labs. We did get some feedback from the Licensing Advisory Committee yesterday. They would like to make it available to a wider range of people beyond just the analysts, such as management. So we've sent out a link, and I'm not sure if Lee sent this to the TACLID yet or not, but if we haven't, we will.
No, I haven't done it between yesterday and today.
Yeah, so we're gonna send out a link so that people can access Top Class, and just for the purposes of watching that training. We've also sent it out to some attorneys, Callie Bailey and Bill Hines, who are on the LAC, Don Boswell at UNT, who's also on the TACLID. We're gonna send it to you, Jarvis, to Mark Daniel, to, I'm trying to remember who else we talked to. Oh, MJ, Akila from HFSC, any of the lawyers that are associated with the labs, plus what we'd like to do is get some feedback from those attorneys about whether they think this could have wider utility. For example, whether, Jarvis, you think other prosecutors might like to watch it, or if you think it's not necessary because TDCAA has it covered in their training. So what's nice about it is it really focuses on forensic examples, which is not necessarily the case in other Morton Brady training. So we will send that out. And it is a couple hours long. I'm sorry for that, but it's a lot of material to cover. Bruce, I think, said it was 2 hours, or perhaps it's 2.5. I guess it depends on how fast you go. But yeah, we'll get that out to folks, and we'd love to hear your feedback, both, the good, the bad, and the in-between. I had huge plans for this. I was going to feature lab directors on video and have dialogues and all these things, and I still want to do that. COVID really, really limited our ability to execute on some of those plans, but I think for the next iteration, hopefully by then we'll be able to do some of those things.
I would move that Jarvis be our actor, since he has experience with that in his other training videos he's done.
Yes.
I'm gonna reach out and touch you, Bruce.
So Jarvis, I'll send that your way. I'm sure your people will be interested in watching it.
All right. Is that it?
Yes, I have a request for a biology break from the people, Dr.
Okay. All right. We will take a 10-minute break. And what time do you have right now?
10:23 on my computer.
All right. So 10:35.
Sounds good.
Live people on here other than Jarvis. So, all right, we're ready to go then. Next is item number 9, Dr. Kerrigan.
So this is just a very brief update on the inter-laboratory validation for the differentiation of hemp from marijuana. Just a quick overview. As you know, this is a collaboration between 4 agencies in Texas: the Texas Department of Public Safety, the Houston Forensic Science Center, Harris County Institute of Forensic Sciences, and Sam Houston State University that helped facilitate the project. Our plant materials were provided by NIDA, the National Institute on Drug Abuse Drug Supply Program, and they provided the cannabis sativa plant material for our project. As I know you all know, this is a qualitative analysis, not a quantitative analysis, so it uses a decision point approach for plant material alone. It was originally proposed by the Drug Enforcement Administration. It was the procedure that was initially developed by them. We made modifications for use in labs here in Texas with assistance from the Texas Association of Crime Lab Directors. Essentially, we developed a GCMS assay that labs could use and incorporate into their own individual analytical schemes for the identification of marijuana. So this is an update since our last meeting. The analytical protocol has been disseminated to the labs. Also the summary of the inter-lab validation, so the data pertaining to the assay performance at all sites has also been disseminated to the labs. And the marijuana plant materials that were provided by the NIDA drug supply program have also been provided to the labs that requested them. And the TACLID coordinated that effort. They obtained the information and the requests from the individual labs, sent those to Sam Houston State University, and all of the labs that made requests for plant materials have received those. Labs received approximately 5 grams of plant material each. In terms of the method validation, obviously we followed the ASTM standard on method validation for seized drug analytical methods. We also incorporated some other elements into the validation. This just gives you a summary of the things that we looked at all 4 sites: selectivity, retention time, stability, limit of detection. We looked at linearity of detection response, even though it is in fact a qualitative assay, carryover precision, both repeatability and reproducibility, accuracy using those NIDA drug supply program known samples, and also some commercial hemp samples that we purchased on behalf of the labs. We also looked at decarboxylation rates, extract stability, interferences, dilution integrity, and we did evaluate measurement uncertainty at 0.3% delta 9 THC in plant material. So that was the legal threshold for marijuana. Just the highlights. We developed 2 methods. We call them short and long method, but basically one of the methods was approximately 5 minutes, so a little under 6 minutes, and one was about 12 minutes long. That's the method we call the long method. And all of the operational labs that participated in our study all elected to use the longer method, the 12-minute method. That gave them greater selectivity, ability to discriminate multiple cannabinoids, including several of the synthetic THC compounds, and also ease of adaptability for liquids and oils, which will be coming later. All of the labs that participated in this project also decided to use an administrative threshold of 1% delta 9 THC in excess of the legal threshold of 0.3. And I'm certainly not going to go through all of the validation data. We're going to be presenting that at the Academy meeting in February, but the highlights in terms of the accuracy of the method, the combined specificity and sensitivity for all sites. So that's Sam Houston, Harris County, Houston Forensic Science Center, and Texas DPS. Among all of the sites, the specificity was 100% and the sensitivity was 94%. So just remember, the specificity is the ability to correctly identify a known negative sample. So there were no false positives at any of the sites amongst the 280 analyses of actual plant materials that were provided by the federal government. And then the sensitivity was 94%. So that's the ability to correctly identify a known positive. So we did include some really challenging samples in our interlab validation. So for example, some of the plant materials that were reported below the threshold included some that had very, very low levels of delta 9 THC. So for example, 0.25% by weight of the delta 9 THC. So some of the false negatives, a small number of false negatives, were partially due to inefficient decarboxylation rates. So you definitely want to have improved specificity at the expense of sensitivity. So no false positives, and tolerate a very small number of false negatives close to the threshold. Other safeguards we have in our method, again, as I mentioned, all of the labs that participated in the study are using an administrative threshold, which exceeds the legal threshold of 0.3. The analytical protocol that was developed is also very likely to underestimate the total delta 9 THC present, because you're never going to have a 100% extraction efficiency of the delta 9 THC from the plant into the solvent. And you're never going to have 100% decarboxylation when you're relying on in situ decarboxylation in the method. And so essentially the conversion of the carboxylic acid to the delta 9 takes place inside the inlet of the GC. So this is all designed to maximize specificity at the expense of sensitivity. Just a few considerations during the course of this project. Of course, we were expecting to see differences between laboratories, but we certainly did see interlab differences. So labs that are deploying this type of methodology should expect to see interlab differences. All of the labs employed conditions on site to optimize their results. So even though we provided a framework for the analytical protocol, all of the labs still had to perform on-site optimization to get the conditions right for their instruments, because remember, we're using the same analytical protocol, but each of these organizations have instruments made by different manufacturers of different levels of sensitivity, and so on and so forth. The analytical protocol developed is not a standard operating procedure, so we distributed a protocol, but we want to remind labs that depending on the individual results that they obtain during their validation, they need to incorporate the appropriate safeguards into their standard operating procedures. And labs really must develop SOPs based on their own individual method performance. And the last point is really that the interlab study that we conducted, we want to make sure that labs understand it does not supplant the need for there to be a full, independent and rigorous validation of an analytical method in the site in which it is used for casework. The folks that participated in this study at the various centers, James Miller and his team of folks, Kay McLean and her team, Charles Klein from DPS, and Jessica Cheng from Sam Houston State University with myself. And we also wanted to acknowledge the NIDA Drug Supply Program for providing materials for our method development and this very extensive interlab validation project, but also for providing sufficient samples for us to provide materials for labs that they might use with other materials in their validations. So that's what I have. I wanted to just mention, I think it's good to note as the DPS actually used this method when the lab started deploying this method, I think towards the end of August, beginning of September. DPS had a fairly significant seizure. I think it was over about 11 pounds in Amarillo, Texas, about 10 bags of suspected marijuana. They used this method, and in fact, it all was below the 1% threshold. So we're really glad that we were able to facilitate the method development, but also the validation with DPS, Harris County, and the Houston Forensic Science Center. But it's being used successfully. I'm not sure if there are any questions.
I have a question. Can you tell us when and to what audiences this will be presented? I know you said the Academy meeting. Are there other national meetings? And then the second question is, do you have a sort of a sense for when there will be a published article on this, or like how long it'll take for that to come out? Because I know you're working on that too.
Yeah, so we have two publication products that are in the works. One that has a lot of the extensive method development that we did, and then another which is in partnership with the agencies here, which has the interlab validation data in it and some of our significant findings. So those are in the works. Those should be, we're hoping, I mean, you can't really control how long it takes for papers to be published, but hopefully in the next few months, we should see those. There's also a symposium at NIST in November. I'll be presenting at that symposium and talking about our experience here in Texas with the Intralab validation and sharing some of the data there. And as I mentioned, we're also hoping to, well, there are actually two things we have planned for the Academy meeting. We have submitted a paper for the Academy meeting, again, with our collaborators, James Kay and Charles. And we also have actually a workshop that we have put together at the Academy meeting. And of course, the scheduling for the programming at the American Academy of Forensic Sciences is happening currently, so we don't know what the program is. The program typically goes out, the advanced program typically goes out in November, but there was a workshop that was proposed specifically to address and provide updates on where labs are currently with their differentiation methods. And I'm actually chairing that workshop, and some folks like Dr. Logan is going to be one of the presenters there. Sandra Rodriguez Cruz, who was obviously involved in the initial development of the method at the DEA, is one of the faculty members. She's co-chairing that workshop with me, in fact. We've got Agnes Winokur, who is the chair of the Seized Drug subcommittee of the OSAC, who's also going to be yes, she's going to be presenting. And then Marcella from NIST is going to be talking about the CANAQUAP program at NIST for plants and oils. So I think we've got quite a lot planned, but I really want to commend the institutions and also the individuals that are here, but also behind them, they had lots of folks that were helping them in the labs. And it really was performing an intralab validation is not easy, and it's even more complicated when you're doing it between multiple agencies. And so I just wanted to say thank you to all of the individuals who participated.
Can I ask a question of, I hope Brady Mills is on the line. I was wondering if we have any, I don't know if he is anymore, but if he is, yes, Brady.
Yes, Lynn, I'm here. Good morning, everybody. How are you?
I'm sorry to put you on the spot, Brady. I realize I do this often, but do you have an update on how things are looking for training of end users? So specifically collaboration with TDCAA for starters?
I do, actually, yes. We had a really good meeting this week about that. So yeah, this method we started working on August 3rd. So we started early in August. We started working the plant material that we had in-house. So those were mostly DPS officers, seizures that were responsible for storing as well. So we started working those in early August. So those reports started hitting DA's offices through our automatic process. So that generated a lot of questions. And working with TDCAA, I think we're going to be able to address some of those questions. So we had a meeting Monday with their training coordinator and then also their DWI expert, because he's kind of been working with the labs delivering training to the DAs around the state for some time now. We're coming up with a 1-hour video that will be hosted on their site that would be available for CEs, for both prosecutors and defense attorneys, both explaining the method, explaining the validation process, and explaining how to present that in court. So that is forthcoming soon.
Dr. Stout, did you want to add anything?
Sorry, I was just stepping back in from another meeting here.
Dr. Kerrigan just presented on the validation for hemp.
Gotcha.
Marijuana. So we can wait until your agenda item. I'm sorry, I didn't realize you just stepped back in.
Yeah, sorry. It's been a week around here.
No worries. I don't know if any of the labs on the line have questions about the information that Dr. Kerrigan presented. I know this is a very significant initiative. And if you have any questions, please feel free to get in touch and we'll coordinate.
Well, we have started reporting results out. And so far, I'm not aware of any like really significant questions that have arisen, but I mean, we've just started reporting results out just a few weeks ago. So I doubt anybody at the DA or anybody else has really had much time to absorb what it means yet.
So to follow up on the comments that Brady made with regard to the DAs and the TDCAA, Brady, I'm really glad to assist with any type of training efforts you have that you're trying to coordinate. We can talk offline about that, but I'm definitely, you can count on me for anything you need with regard to training.
Yeah, thank you. That'll be very, very helpful. And I think a lot of it's intake attorneys that are getting the reports, and so they're asking, well, what is the quantitation? And so we just need to bridge that gap to explain why we as a state chose to go this way and what those results actually mean when those intake attorneys are looking at these new reports that are identifying plant materials marijuana.
Thank you.
Anything else?
Brady, just to reiterate, like DPS on plant material, that is, obviously, I remember you guys are not doing misdemeanor amounts, but on felony amounts, y'all are good to go on plant material, just not on anything else, correct? Like edibles, vapes, things of that nature.
That is correct. So we started with plant material for DPS officers because we had to get those out of storage. We're done with that. That backlog's been cleared across our 13 laboratories. And so here this month, which is steadily getting away from us now that we're in late October, we're going to open up the doors to partner with the local law enforcement to start bringing in felony level plant material cases. And then liquids and oils and eventually edibles are kind of downstream projects that we're just starting the validation process on.
Okay, anything else? All right, let's move on to item number 10.
So we received updated root cause documents, both for the specific Fred Lee case and how that was processed, as well as for the additional work that was done system-wide. Dr. Badoli and I looked through those materials and had a call with Dr. Nelson and Brady about those. We made some comments and offered suggestions about improvements we thought could be made, and we need to take a look. I think they have done that, but we have not had an opportunity to go through that material in any detail. My hope is that once everyone feels comfortable with the way the information's been presented in those quality documents, we'll be able to draft a report, and my hope is that it'll be done by January. Dr. Badoli, do you want to add anything to that?
No, I think you covered it well.
Okay, so that's where we stand there.
All right, any other comments on that?
Yes, this is Patrick. I have a quick question about document B. Just a curiosity, at page 3, where there is the assessment of the risk level and or the severity rather, it's called moderate and the risk level is medium. Can I just ask a little bit the motivation or how it works, the evaluation of those severity and risk level, please?
Yes, this is Brady Mills with TPS. So that was on our look at the situation around the state and not necessarily the issue there in Houston. So we looked at as a preventative measure, and going through the training and preventative ideas and topics that we have in the document, we did feel that rating that both risk and the priority was appropriate.
Thank you, Brady.
All right, anything else?
Dr. Busini asked the same exact question, and they explained the same thing to us, because in terms of the incident itself, the reporting out of incorrect results to the trier of fact, we thought that would be rated more severe than moderate. So I assume that's sort of a similar point to what you're getting at. So we as soon as we have what would be considered the final quality documents, we will distribute them, and I'll start working on a draft report and distribute that draft as well to the group.
All right, item number 11 is the final report from the panel regarding Signature Science.
Right, so if you recall, we had a self-disclosure from SIGSCI with respect to an evidence technician. And what happened in this situation was that a number of sexual assault kits were received in the laboratory on a given day. Most of them that came in at the time period in question were for a single client, but there was one sort of solo kit that came in from a separate submitting agency. Evidence technician somehow forgot to open that kit, and that kit went forward to a DNA analyst who looked at it and noticed that it had not been opened, asked some questions about it. The evidence technician maintained that she had indeed opened it, and when the DNA analyst next looked at the kit the following day, she noticed what she thought was an indication that the evidence technician had come in and, realizing that she had failed to open the kit, opened it, and then made a false entry on the chain of custody master log to show that she had opened it when she actually hadn't, and then backdated an evidence tape closure on the kit to make it look like she had opened it the day before when she actually, or the day that she should have when actually she missed it. So Signature Science disclosed this to the commission as an incident of misconduct, an intentional, dishonest act on behalf of this, or by this particular evidence tech. So we worked through this with the panel. We interviewed a number of people from Signature Science, including the evidence technician. And through the process, and after looking at the statute, we created this report that described everything. The committee agreed with Signature Science's accounting of the facts of the incident itself. In fact, the evidence technician did not disagree with the information as presented. She acknowledged that she did this out of panic, out of a sense that if she somehow, if she admitted that she had not opened the kit, that she would face some level of disciplinary action from the lab. We talked with a number of people and asked them whether they felt any similar pressure, that, you know, whether they understood what the obligations are, whether they felt pressure not to make mistakes, and, you know, pressure that could mount to the point where you would lie about having opened something and then try to cover it up by making it look like you had. Nobody expressed any indication that that kind of pressure was being placed on them by management or anyone else in the chain of command. You know, people acknowledge that this is a profession that's very stressful in many circumstances, but that's sort of a commonly held observation by people who are in this line of work. But nothing that indicated a culture so severe that it would lead to someone being dishonest about the handling of forensic evidence. So having said all of that, staff is mindful that this evidence technician is not a licensed analyst. She is not a forensic analyst. Whether in the future she wants to be or not is not particularly relevant for purposes of drafting this report. And so the conclusion that we felt was the most appropriate to reach and most in line with our statutory authority was to accept and concur with the disclosure because the law states that professional misconduct is an act that would violate the standard of practice an ordinary forensic analyst or crime laboratory would have followed. So the crime laboratory's activities encompass more than just what an individual forensic analyst does. And so we concurred that this was an appropriate disclosure, and we don't make any comment as to potential future licensing repercussions because this is not a licensed analyst, and we would have to consider her application if and when she submits one. So I hope that's clear. Does anyone have any questions?
All right, is there a motion to adopt the final report as drafted by the commission staff?
I move so.
All right, is it second? All right. All those in favor say aye.
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 Opposed? Okay, motion carries. The next item is an update from the investigative panel regarding DPS Austin, the materials trace disclosure.
So you may all recall that this disclosure involved an analyst from the trace evidence section at DPS in Austin who appears to have lost a hair when opening evidentiary items, and realizing that she lost the hair, what DPS disclosed to us was that she then proceeded to renumber the items to make it look as if the hair had not been lost. And there is, and she was let go from DPS for this reason. There is extensive material that we obtained from the Office of Inspector General at DPS, including video footage of each step in this process. Robert Smith and Dr. Busini have done the lion's share of the work in reviewing that footage. We had taken the step of requesting an interview with the analyst, which she originally agreed to, but then changed her mind when we asked her to be prepared to go over the footage with us. So the remaining actions that need to be taken before we draft any report, we need to interview the key folks at DPS with the entire panel. I think Dr. Busini and Robert have a good idea of what they viewed on that footage, but we need to round out the interviews and make sure that we feel comfortable about the conclusions before we issue any formal report. So that's where it stands. And I would like to invite, of course, Robert or Dr. Busini, if you have any other comments you'd like to make now, that'd be great.
Yes, Lynn, as you said, so the panel is still working on it. We had the opportunity to review some of the videos, the phone interviews with the people involved. I think that it's important to gauge both sides, because for any allegation there is a response, an alternative explanation of the facts. So it's extremely important with the video and the audio and all the documentations that we have available to address all of this. And it's what we are working on at the moment. And so yes, as you said, the next step will be to meet with the panel to share thoughts and see how to move forward.
And the OIG gave us a lot of information, and I'm really grateful to Robert because he's taken the lead on reviewing all of that and pulling out the key materials that go to our investigation, because DPS was looking at it from a certain perspective. We also need to look at it from a certain perspective based on our jurisdictional authority. So it's a lot of work, but we're making our way through it.
And Aline, I want to mirror that thoughts. I really I want to thank Robert for the hard work and make available all these materials that are very useful for this investigation.
Thank you.
And you anticipate that the analyst will not interview at this point?
I don't believe so.
Okay. All right. Any further discussion on that? All right, let's move to item 13, which is an update on the release of the Quattrone report.
Right, so the Quattrone Center for the Fair Administration of Justice has released a massive report on, which is essentially designed to follow up on the report that the commission released with respect to the Austin Police Department's DNA lab. And it's 150 something pages. It has lots of observations and recommendations, some of which are directly targeted to what the commission should be doing. And so I had thought originally about including it as an agenda item here, but I think it really merits its own meeting. We rarely have meetings for specific agenda items. We've done it in the past, but it's been a long time since we've done that. I just don't see how we can give it the appropriate attention without having a separately scheduled commission meeting. So my suggestion would be that we try to schedule something between now and the end of January, where we would invite John Holloway to present, as well as any other stakeholders in the community here. This report goes over everything from what we observed to what direction the laboratory should be moving in. I mean, it's making recommendations to the city and county about what they need to do to reconstitute their laboratory. I mean, we're at a similar juncture here as HPD was before HFSC was created. I don't know if I'm adequately expressing the significance or potential significance of this report, but it is major. And I hate to impose on your time more than we already do, but I just can't see how we can do this in the context of a regular quarterly meeting without sitting on Zoom for 5 or 6 hours potentially. So I would think the meeting would probably be 2 or 3 hours just to go over this. But it has national implications and it has implications for our commission in particular.
Yeah, that sounds like a good idea to put it as its own standalone. So you're going to need a motion on this. Is that correct? To set another meeting between now and the end of January. Okay. So
public meeting, of course.
Right. So do I have a motion to essentially instruct the staff to set up another separate meeting between now and the next quarterly meeting?
So
Make the motion.
Okay, I've got a motion and a second. All those in favor, say aye.
Aye.
Any opposed? Okay, that passes.
Lynn, I have a question. When is our next scheduled meeting for the commission?
I believe it's January 29th, but let me just confirm that, Jarvis, so I don't misspeak.
That's right.
29th, Friday the 29th of January.
I guess I'm just trying to figure out or wonder if the day before, is that a possible date for the meeting? Or do you need it kind of separate and apart wholly from our normally scheduled commission meetings?
So the challenge with the day before is it already has other meetings. So the TACLID will meet then, the licensing committee will meet then, and we do it that way. We've been doing that way for a long time.
Okay.
And then the outcome of this meeting would be included in the minutes for the January meeting, or a separate presentation in the January meeting after we've already gone through with this?
I think it would be all done in a standalone session where we would have our own recordings and our own minutes, and it, you know, our whatever comes out of it comes out of it. Then if there needs to be follow-up at the January meeting, we can include it as an agenda item, but it'll be a much shorter agenda item than what we would have done at the standalone meeting. I mean, I'm hoping we can get it all done in one day. But I'm going to need to do some work really to prepare for that and to make sure we can isolate those items that have implications for us. You know, it'll be interesting to see how the commission reacts to some of the items that are in there. And we need, they're not small.
Yeah. Well, we can't even really predict until we get the meeting done to determine where we go from there.
Right.
Yeah. Okay. All right. So that motion is carried. So the next would be item 14, which is the developments by the committee addressing the initiatives for pediatric sexual assault. Dr. Downing.
Sure. So my update is just that I presented this to the CEO of the International Association of Forensic Nurses, which is the organization that really is, that sets the standards of forensic nursing practice. And I'm just pleased that she received this positively and not as a critique of pediatric same practice, but more very open and also interested in protecting the integrity of the practice. So we will look at moving forward and finding ways to delineate what constitutes pediatric SANE expertise, as well as develop some recommendations based on what we find.
Thank you. All right. Any discussion on that? All right, then let's move to item 15, which is an update from the crime scene working group.
Yeah, so we have had a couple of very productive meetings. One of them we spent outlining the voluntary license criteria for crime scene reconstruction, and that was very well received. And we also laid that out in front of the LAC yesterday, and they gave us some feedback. So we'll be moving forward toward a rulemaking for that. But we do need to put in place the modules that people are going to be expected to satisfy and really think through what course offerings are available and what the path will be for people who want to achieve this license. The second thing we discussed was a guidance document for crime scene reconstructionists so that they can understand the limitations of DNA analysis, especially when it involves mixtures and the reporting of results using likelihood ratio, where there's one hypothesis sort of weighed against another hypothesis. So we had some fantastic feedback. I want to thank Dr. Nelson. I'm not sure if she's on the line, but she gave a very thorough presentation on DNA analysis, what it means, what it doesn't mean, what the laboratory does, and you know, step by step by step. And it was really great. I mean, super helpful. The lawyers on the call were like, we need to be training. She needs to give this to everybody. It was good, really good. And from that, we had a discussion with the group about next steps. And what's so beautiful about this particular group is it is interdisciplinary, truly interdisciplinary. Judge Herbie's on it. We have Bill Werski there. We have some Rangers. We have Shelley Rossi from Montgomery County, Brett Behrens, who's from, I think I'm going to mess this up. Is it Grapevine PD? It's not. Oh. From a North Texas Police Department, and for reasons that his particular department is escaping me at the moment.
He's with the Irving PD.
Thank you, Irving. Thank
That's
you.
where I'm from. That's how I remember.
Oh, super. Okay, so he's from Irving PD. Thank you. And apologies, Brett. So the group is, and then we have all these DNA folks who are helping us out. And Sue Howe is there from Tarrant County. I mean, it's just really good. So they came up with some great ways of moving forward. And I think there was a perception that we could do something pretty groundbreaking in terms of laying out a mock crime scene. And Dr. Stout and his CSI team offered, I guess they have a house that they use for crime scene reconstruction training in Houston. And they offered up the use of that to really lay out a scene and do all of the photographs and everything else. And then the labs are going to create some reports that are meant to reflect the analysis of certain exhibits or biological evidence, so certain evidentiary samples submitted to the lab. And through that process of releasing reports, the laboratories, we're going to illustrate certain concepts and limitations of a DNA result. So we're going to see from the beginning, from the photos of the scene all the way through to the report, how, what the scope is, what DNA can and cannot say about the evidence and about what may have happened at the activity level point for the crime scene. And it is super exciting. And I am really grateful to Dr. Stout and his team for letting us use the facility, to Chelly for coming up with these ideas, to the DNA folks for being willing to, put the work in to create these lab reports. Our hope is that we'll get one from every single publicly funded lab. And the reason we want to do it that way is so regardless of what jurisdiction the law enforcement agencies or the prosecutors are in, they can take a look at, like, let's say, Don always used to say, well, in Tarrant County, we had 5 different DNA labs. Well, for those prosecutors, they'll be able to look at this mock scenario and the reports for all of those laboratories so they can see how it would look. And we're really excited about this initiative. So any questions or comments? Sound good, crazy, or I guess.
Sounds great.
Okay. All right.
All right. I was going to say, all right, if no further discussion, let's move to item 16, which is an update from the Association of Crime Lab Directors, Dr. Stout.
Hit the right button here, sorry. Most of anything that's gone on around TechLab has been getting the hemp marijuana stuff distributed. I think we had 7 labs total outside of DPS that have requested the reference materials, the marijuana reference materials, the NIDA reference materials. I think those have all gotten distributed. Thank you, Sarah. We've gotten the validation package that the group put together, that's been distributed out through TechLab. And some other things that have popped up. I did an op-ed in Chronicle around hemp issues and also concerns about laboratory resources for impaired driving as marijuana starts taking off and what we do about impaired driving issues. So I think now starting to see a few questions from laboratories as they're starting to validate their own methods around this and get going with things. Also is getting distributed the new CSAFE stats class. I think we've got that distributed out to everybody, as well as just sent out encouraging TechLab and those non-licensed members to participate in the professional standards training. I had sent a while back, speaking of the OSAC stuff, we have the one group that we've put together that are toxicology types to look at the registry standards that were up there. We had started that before the validation standard had gone up. We've not dug into the validation standard. Basically, of the two standards that are up there, and I think, Lynn, you'll probably talk some about the wider idea about OSAC, because obviously trying to do this as small groups looking at standards is just not really gonna get there. But the two standards we looked at were recommendation 37 and what was the other one? Sorry, I just had it up here. And there it is, standard 17. So both of them are pretty reasonable. The discussion we had is both are reasonable. They should be something that the laboratory should be able to implement, but need to highlight particularly the recommendation 37, which has to do with testimony and qualifications for toxicologists. This is a recommendation. The SWIG tox recommendation, particularly for training standards and credential standards, is also a recommendation, not a standard. And because the underlying credentialing could be really an issue for some laboratories to be able to contend with. But then standard 17, which is traceability in forensic toxicology, the group thought was reasonable. There's about a year to come into compliance with it. That should let most labs be able to come into compliance. We had some discussions around particularly like thermometers that are used for monitoring refrigerator storage and things like that, how you deal with traceability in thermometers. But it's something that probably laboratories can figure out how to contend with. So that's kind of the TAC-clad world at the moment. Oh yeah, and Elise was voted as the secretary for a second term. So thank you, Elise, for being willing to do that.
My pleasure.
And of course, now I have a dump truck going by.
Well, I'll take over, Peter, so that's probably good timing. So one of the things that's happening is that we are having more and more OSAC documents come onto the registry. And so Peter and I had a call where we talked through, and I had a separate call with Mark Stolero about this, where we talked through what ideally would we be doing in Texas to evaluate these documents and implement them. And so we talked through some ideas, and I put them in this outline. One is very basic. It goes to what Peter was saying. You know, we need subject matter experts on the ground here to evaluate, to read the documents, evaluate them if they haven't seen them already, to coordinate training for labs on what the standards are, what they mean, to help the labs perform their own internal gap analysis and identify any barriers to implementation they may have. Is there an instrument they don't have? Or, you know, whatever it might be. And then that's one Roman numeral. That's just one task. Then on top of that, we need to address the issue that Bruce has raised a number of times, which is that the commission may wish to move forward on some of these, but may want to provide some clarifying information or comments about what we think the language is meant to convey. We also need to assess, the commission will, at what point each of these registry documents can move from a voluntary recommendation for adoption into something that we really do expect is being done in each lab. Some of those documents will be no-brainers, others not so much. So there's that process. Then we think it would be really helpful to have a way to facilitate greater participation at the local level during the SDO process itself, during public comment, so that we're not contending with documents at the last, or things that we're unhappy about at the last minute. Now, as I am well aware, because I have submitted many comments, the act of submitting a comment does not mean that the committee will incorporate your comment or do anything different than what they were planning to do. But it would be nice to facilitate more active participation earlier on. So we're not only looking at documents once they get the registry. And then on top of that, we want to help labs, help practitioners who are strapped for time as it is, to have a heads up about, hey, you know, we were talking about this at the LAC yesterday. There's a firearms examiner in a leadership role who's on the LAC, and she might like to participate in the comment period, but sometimes that happens so quickly and you have all these pressures in the lab. Do we have a way to help trigger notifications to people like, hey, you might be interested in this one that is up for public comment right now? And then finally, we want to have some sort of a portal where the labs can communicate their individual statuses with respect to adoption of OSAC standards and guidelines, and where they can communicate which standards and guidelines are in process, what is, which ones have been adopted, what the expected implementation date is, which ones you're just not doing for any number of perfectly reasonable explanations. And then finally, this is not as applicable to the labs themselves, but we want to train the end users. What is the standards development process? What does each standard mean? What does it not mean? What should the lawyers be asking in terms of questions about this stuff? So when we laid out all of these things that we think should be happening with respect to OSAC, it's a lot of stuff. And Peter and I said, I don't know that it's realistic to think that you and I are going to be able to do all these things. So long story short, if people agree that that these items and anything else you want to add to it are worthy endeavors, we think there's an opportunity for the commission and NIST to work together to fund a position of a project manager whose job it will be to help us with these endeavors. And so I guess, I'm not sure because we still need to work through it, but there seems to be potentially an option for grant funding to help with this. So these are the ideas that we've come up with. I don't want to end up with a situation where there are 50 documents or 100 documents on the OSAC registry, and we just have been so swamped with other things that we have not really evaluated them and worked toward implementation as a community. So what do people think about this idea?
Well, I think I'll jump in. I mean, it's a direction that we've been moving in for a long time. All of the outreach activities that we have that have been coordinated through the OSAC are moving in this area. Before you even talked about having the dedicated position, I was willing to volunteer. I think the Institute is the obvious place to take on some of this. So I was going to volunteer that we take on some of that responsibility in terms of communicating with the labs, doing the gap analysis and bridging some of the gaps, because there are significant gaps in terms of training. And just as we had through the Institute developed the training on the mandatory legal and professional responsibility, I think that I'm willing to volunteer our resources at Sam Houston State University to meet this goal. I think it's such an important issue. I've drunk from the Kool-Aid in terms of standards implementation as a FSSB member for 7 years. My second term just ended, so I kind of got my life back on October 1 when our term limits went into effect, and I'm no longer on the FSSB. But in terms of implementation, can I just mention a couple of important things we have coming up? We actually have JP Jones from NIST and I are chairing an implementation. It's actually going to be an interdisciplinary session. As I mentioned before, the final programming for the American Academy of Forensic Sciences is still being worked out, but we anticipate, we're hoping to have an interdisciplinary symposium, which will be free of charge at that meeting for people who are registered. specifically to address the challenges and solutions associated with standards implementation. And so we'll have individuals that are going to be presenting on various standards, not talking about the standard itself, but focusing on the challenges that exist to implementation from a global standpoint, and then discussing how they were implemented in a practical sense within their operational labs. And Eric Pekorek at the FBI is actually going to be presenting on the toolkit that we have developed, that the OSAC program office developed to help with implementation efforts. So I think that's going to be, that'll be a good resource. But you're absolutely right. There is a real training need in terms of specific standards. One of the things I will mention is that the SDOs themselves are already working on that issue. But I think if we could have some training at the state level, that would be great. And I think we're well positioned to do that because obviously we do sort of distance learning well. So
that sounds great. I think we can put our heads together between now and January and try to flesh this outline out a little bit better and talk to JP and NIST and see, you know, what's the best course forward. But as Peter and I were looking at, like, how do we do this and do it well? It seems like more than two of us can
well, it's more than the TACLID can take on, clearly, because those folks are already incredibly busy. But I think it would be a good opportunity for there to be maybe a partnership with an Institute of Higher Education to help with some of the data collection, but also gap analysis and training. There was one other thing I wanted to mention to your point, Lynn, when you said ways to engage labs earlier in the standards development process. And I think everybody in the meeting knows this, but I'll mention it just for the record. And that is that under OSAC 2.0, which went into effect October 1, of course, now in the new process, a standard, an OSAC proposed standard will be available for community use. And it will, so that will actually, and it will be available for public comment before it goes to the SDO. So this will be a public comment period that exists pre-SDO. So there will be opportunities for individuals to provide feedback on important standards before they actually go through what is, of course, a very lengthy SDO process. It can take several years to produce an American national standard. So I think that's important because we want the labs to engage earlier in that process. So.
All right, any further discussion?
I had one other just kind of TACLID more oriented thing. The Criminal Justice Committee in the House sent out a request for comment on House Bill 1325 items. I've sent that out and been getting some comments from TACLID labs to provide that back to the state ledge. So we'll get that assembled on commentary in 1325 because that'll have, there's still some things that have to get straightened out about what we do on hemp and marijuana identification, and it's got to get legislatively, not the least of which is resources. But as Jarvis was mentioning about asking about stuff other than plant, there's some real complexities to the stuff other than plant that isn't even analytical. It's the what in the heck does dry weight mean? What in the heck? I mean, 10 milligrams of THC in a 100-gram cookie is still less than 0.3. So that, strictly speaking, would be hemp. Well, that ain't right. But that's basically where the legislation is. We got to get some of that stuff straightened out.
All right. Item 17, consider proposed agenda items for the next meeting.
So we will circulate two things. One is the Quattrone meeting information, and then separately the agenda the same way we always do.
Okay. 18 is schedule the location. Well, I think we know what the location is going to be. It's going to be at wherever we are right now, probably. And then we've got the meeting in And I guess, will you start planning, I guess, for the rest of the year then?
Yes.
Okay. All right, so the last item is the public comment period. Catherine, if you want to give the rules to that. I don't know if we have public comment left, but
I do not think we have any public comment.
all right.
Yeah, I didn't get any forms back or anything. So as far as I
We've
know,
had
no.
2 people speak already, but they
Correct.
spoke during the time period. Were those the 2 that we had anticipated wanted to speak?
Yes. We had
Okay.
one more person that wanted to speak, but her complaint was dismissed, and so she didn't follow up on it.
All right, I guess, well, so let me ask, are there any public speakers at this time? Okay, do I have a motion to end the meeting, to adjourn?
I'll move.
Second.
There's, all right, all those in favor say aye.
Aye.
Opposed? Okay, all right, well, thank you. Have a good rest of the day, and we'll, I'm sure, be in communication soon.
Thank you, everyone.
Thank
Thank
you.
Thank you.
Bye-bye.
Goodbye.
Everybody.
Bye.
Have a good weekend, everyone.